Hello, my name is Dorota Boissel and I'm a general counsel at Main Partner. In today's presentation, I would like to introduce you to a trust as an asset protection tool. So let's start by explaining what asset protection is. It can be described as a set of legal techniques which are dealing with securing assets of individuals or businesses from the claims of creditors without perjury or without the risk of being seen as a tax evasion. Who shall consider asset protection? First of all, anybody who has assets, and obviously, the more assets you have, the more crucial it is that you protect them. Also, persons who are exposed to higher risk of liability should consider asset protection. Therefore, asset protection is best suited to either high net worth individuals or business owners, future spouses, persons with a public profile, as well as high liability professionals such as doctors or lawyers. When should you think about asset protection? Well, as soon as possible. As you will see, it is usually too late to think about asset protection when you have creditors already existing and knocking at your door. Now that you know what asset protection is, I would like to explain to you how a trust can work as an asset protection tool. So what happens with the creation of a trust is that the owner, the settlor, transfers certain assets from his or her personal assets to the new legal owner, the trustee. From this moment, the personal assets become part of the trust fund. In general, personal creditors of the settlor can only satisfy their claims from the personal assets of the settlor. And because these assets transferred to the trust fund do not form the personal assets anymore, the personal creditors of the settlor cannot satisfy their claims from such assets. Hence, a trust can ring-fence the trust fund from unwanted lawsuits in the future. But a trust is not the only asset protection solution, and here I would like to introduce you to some alternatives. These are insurance policies, retirement plans, limited liability companies, and prenuptial agreements. Insurance policies are a great solution, especially for those who have this high liability risk professions. So, for example, for lawyers, for doctors. What insurance policy gives is that in case of a lawsuit that is successful, such insurance policy should cover the damages and also the legal fees. And although it is a very useful tool, it is limited by nature. There is usually a maximum coverage. And therefore, if, for example, the lawsuit is for $3 million, but your coverage is only for one, it might not be enough. And therefore, insurance policy cannot be seen as a comprehensive solution. Then we have retirement plans. In certain jurisdictions, a retirement plan can be seen as an asset protection solution because the assets transferred to the retirement plan are not available to the creditors, personal creditors, or at least not to all of them. And therefore, a retirement plan, although also a possible solution, has some limitations. In some jurisdictions, for example, still claims related to taxes can be satisfied from such retirement plans. Another solution is a limited liability company. This is a solution for anybody who is involved in business activities. And this solution is related to the division of personal assets and business-related assets. If there are creditors of the company, they can only satisfy their claims from the assets of such limited liability company, and as a rule, they cannot sue the shareholder. However, in many jurisdictions, there is a concept of piercing the corporate veil, which means that under certain circumstances, the creditors of the company can still satisfy their claims from the personal assets of the shareholder or directors. Another solution for asset protection is prenuptial agreement. This is a solution for anybody who is willing to get married, and it is an agreement that is signed between future spouses that regulates what assets will belong to each of the spouses during the marriage, as well as in the moment of the dissolution of it. It is once again a very useful solution in certain cases, but it also has some deficiencies. One of which is that it might start the marriage, as to say, of the wrong foot, from the standpoint of legal controversies rather than a cooperation. So as you can see, all of those solutions, even though they are actually very useful, they seem to have some limitations that do not apply in case of a trust. A trust as an asset protection tool does not have any maximum coverage like insurance policy, meaning that all the assets that you transfer into the trust will be protected. It also protects you against all types of claims, unlike a retirement plan. There is also no concept of piercing the corporate veil. There are certain cases under which a trust can be considered non-existing, but the threshold is much higher. And also, it is not a controversial tool, such as a prenuptial agreement, for example. So to sum up, it seems that asset protection for high net worth individuals should be seen as a multi-layered approach. Therefore, it is recommended that you use various of different techniques. However, arguably the most comprehensive asset protection tool is a trust, because it protects you from various claims of all types of creditors with no maximum sum protected. However, in order to achieve all of these goals, a trust has to be set up properly, and I would like to discuss with you what does it mean in my future presentations. Therefore, stay tuned.